workers' compensation claims can be more limited at times than being able to file a lawsuit in the court of law. So in this case, the Murphy Oil wanted the court to find that she had to get her money, her claim for her injuries from the Workers' Compensation Act. And she was saying, no, I'm allowed to go to court. So here's the background facts. Stegall worked as a cashier at Murphy's Oil store in Balch Springs, Texas. On September 25th, 2017, Stegall's aunt drove her to work and dropped her off at the store in the parking lot. Approximately 10 minutes before Stegall's afternoon shift was scheduled to start. So she had not started working yet. And on her way across this parking lot, she stepped into a pothole. She fell and she seriously injured her ankle. 3 men, including her supervisor, helped her into the building. She was in significant pain. She incurred $13,000 in medical bills, and she was unable to work at that time. So she initiated a workers' compensation claim, but it was denied. So her claim was denied, and oftentimes at that point, a person might quit on trying to collect any damages. But in this case, she did not do so, and it turned out to be to her benefit. Now, they denied her workers' compensation claim, saying that she had not sent the insurer the necessary information. So when you're dealing with an administrative body like Workers' Compensation Division, they're going to look for any administrative reason, such as not sending in information, to deny a claim. It's important at that time with any of this to have experienced counsel that can make sure that you don't run into any hiccups like this. But in this case, she did not send any insurer information, but she then went on to sue Walmart stores on a claim of premises liability because of the pothole. And then she added Murphy Oil. So a lot of the time in a lawsuit, you have to, over the course of time, recognize who you're suing for that liability. It's not always obvious who owns a given piece of land where you may have been injured. So in this case, she eventually added Murphy Oil as part of the lawsuit. And basically, Murphy Oil said that there's a defense in law called the exclusive remedy provision of the TWCA. So in Texas, you're only allowed to get damages from Texas Workforce Commission. You're not allowed to sue otherwise because of this law that says that the Texas Workforce Commission is the exclusive remedy. It's the exclusive place you're allowed to collect. So she said that no, it's this particular law, the exclusive remedy provision, does not apply because she was not in the course and scope of her employment when she was injured. And as such, she's allowed to sue in the court of law. So the court, you can see this is the actual primary source of law. This is the opinion. The court's going through the facts and discussing whether or not she was in fact working in the course of her employment. They noted that her injury occurred while she was exiting a vehicle, that she stepped into a pothole. She injured both of her ankles, and they noted her medical bills again. They noted that she was an employee at the time that she was walking into their building, but she had not yet clocked in. They noted that she did not get workers' compensation, and they noted that this particular parking lot, this was really, I think, an important fact in this case. The parking lot where she was injured is used by both employees and the public. Probably if the public was not allowed to be on that premises, then it would be difficult to argue that this was not in the course of her employment. But because both public and private people, employees and the public, could be on this parking lot, it's possible that she was there not working yet. And so ultimately, at the trial, she won the damages, almost $13,000 in medical expenses, but also won $5,000 for past pain and mental anguish, and $2,000 for the physical impairment that she had in the past. So she won some more damages at the trial level. And then they go on to talk about this very important law that anybody looking at a workers' compensation claim needs to be familiar with. And that is The recovery of workers' compensation benefits is the exclusive remedy, that's what we were talking about, of an employee covered by workers' compensation insurance coverage or a legal beneficiary against the employer or an agent or employee of the employer for the death of the work-related injury sustained by the employee. Now, Stegall argued that her claim did not fall within this rule of law that we're talking about because she was not in the course and scope of her employment when she was injured. Course and scope is defined to mean, and this is where you're going to want to look for yourself if you're analyzing your own likelihood of compensation outside of your Texas Workforce Commission Act. Course and scope is defined by the TWCA to mean an activity of any kind or character that has to do with and originates in the work, business, trade, or profession of the employer that is performed by an employee while engaged in or about the furtherance of the affairs or business of the employer. The term includes an activity conducted on the premises of the employer or of other locations. So that's broad. It sounds like, wow, when you read that, almost anything to do with the job, it sounds like would be included. They're really trying to make it that you have to go the Texas Workforce Commission route to collect damages. It sounds very broad. But the court said she had not yet begun work, and they quoted a couple of cases that have already found, and they said it's well settled. Whenever you see the words well settled in a case, watch out, because the court is going to follow what is well settled. That's the law of our land. That's what we all, as a people of the country, are supposed to be able to rely on together. Well settled rules. They said the general rule, it is well settled that the benefits of the workmen's compensation statute do not apply to injuries received going to and from work. Course and scope does not include transportation to and from the place of employment. So that was what they said. And then Murphy Oil, that did not want her to prevail on this, said that parking lots are so closely related to the employer's premises as to be fairly treated as part of the premises, and that they even have this parking lot set up so that employees can park closer to their work and authorized visitors. This is part of their place of work. So in most instances, such an injury is suffered as a consequence of the risk of the hazard in going. So they're talking about, no, we've already said, if somebody's getting hurt on the way to work or leaving work, these are hazards that these people are enduring just like the public is. And that's why they have access to a court system just like the public would, regardless of the fact that they are employees. So ultimately, Stegall prevailed on this workers' compensation case in the sense that she didn't have to go the workers' compensation route. She was able to keep those damages through the regular court system